Thank you. Thank you, ma'am. Welcome, everyone. On behalf of IGNA Legal, I welcome you all for today's webinar. Just to give a quick introduction around IGNA Legal. IGNA Legal family has been together now for over 4 months. And with the joint thought process of Bhaskar sir and Sridevi ma'am, IGNA Legal has taken the initiative of training young advocates on practical aspects of the profession. And this is purely voluntary, and we're really thankful for ma'am and sir to take us through this training. During the course of the training, every day, morning and evening, we have sessions which are over the acts that are currently prevailing. And we try to discuss among ourselves, get the case laws onto the platform, and try to understand it together, which is helping us more and more to understand the nitty-gritties of laws and how they are changing over time. And over the weekends, we invite distinguished guests who are specifically going to talk about areas which are key in nature. And these external speaker sessions have been pretty useful for us in learning and gaining in-depth knowledge within the laws in that space. So as a part of that, today we are inviting Sri Kiran Palakurthi garu to speak on Hindu Succession Act, the practical approach that every advocate needs to learn. With that being said, I would hand over to my colleague Chaitanya to give a quick introduction for Kiran garu. Thank you.
Hello, sir. Good morning, sir. Good morning, ma'am. Hello and welcome to all to this webinar. Myself, Chaitanya, member of IGNA Legal Associates. Thank you for taking the time to join us today as we talk about Hindu Succession Act, a practical approach. I am very pleased to welcome our distinguished speaker, Kiran Palakurthi garu, advocate and member Bar Council of Telangana. He pursued his law and LLM from Usmania University and is an alumni of PG College of Law, Bashir Bagh, 2004 to 2006, and he specialized in LLM constitutional law. He was enrolled in the year 2001, practiced in Nalgonda district courts for 3 years. In 2004, he started practice in High Court. He joined as junior civil judge in May 2008. He resigned in 2014 and resumed practice in High Court. He was elected as Bar Council of Telangana, member of Bar Council of Telangana in 2018. He deals with matters relating to Constitution of India, civil and criminal matters. He trained more than 1,500 advocates, above 100 selected as junior civil judges and district judges. He received 2 gold medals in law, and he was awarded as one of the best from the Judicial Academy as Best Judicial Officer. Sir, we are very much pleased to have you here to give lecture on Hindu Succession Act, sir. Thank you, sir, for your time. Well, we welcome you, sir, on behalf of IGNA Legal Associates, on behalf of Sridevi Madam and Bhaskar, sir. Thank you, sir.
Thank you, madam. The organizers of this event, Bhaskar garu and Sridevi madam and other staff of IGNA Legal Associates. At the outset, I would like to congratulate them and appreciate them for conducting these kind of programs, because it's a part of legal education, continuing legal education. I feel legal profession is a good profession that gives very much satisfaction and happiness, because we serve the public. So we are learning for public good. We have to learn. It should not be stopped. Continuous legal education. For the past 2 years, we have been witnessing the pandemic COVID. There is a less opportunity for the young members of the bar to learn because they are unable to attend the court. There is a less chance for them to learn things from seniors by observing their cross-examination, arguments, or trials. So this program is being conducted by Sridevi Madam and Bhaskar sir. I have been requested to talk on the subject Hindu Succession Act today. there has been a lot of confusion on this aspect, because I have been receiving, our office receiving several appeals and applications, CRPs from subordinate courts, where judges of subordinate courts interpreting the provisions, and there is a confusion because of various judgments delivered for the past 2 or 3 decades, and one judgment has put some conclusion to the confusion regarding section 6 and 8 of Hindu Succession Act regarding the rights of the female members of the co-personary and other implications. There is also a confusion between self-acquired property and joint family property and co-personary property, and other provisions like dwelling house and pious obligation. All things are there, and if these provisions, it is a small enactment, Succession Act consisting of nearly 30 provisions. If these provisions are discussed in detail with practical inputs, I felt that it would be better serve the purpose of today's lecture. So friends, Hindu Succession Act 1956, it is an intestate succession, testamentary succession and intestate succession. Why we should learn Hindu Succession Act? What is the purpose of learning Hindu Succession Act? Friends, law of property, transfer of property, governed by Transfer of Property Act, it deals with transfer between 2 persons, transfer inter vivos we call it. That is transfer between 2 persons, sale, the moment sale deed is executed, the rights of the vendor, seller will vest in the buyer. It would take immediate effect. That means the purchaser would become owner of the property, that is for consideration, and transfer inter vivos. It is a transfer of property which would take immediate effect. And another mode of transfer is gift. Gift also, the donor-donee relationship. The moment donor gives the gift, executes the gift deed, the donee accepts the gift, the donee would become the owner of the property. And mortgage, it is for securing payment of a debt or loan. Lease, temporary interest in the property, that is possession will be transferred, not the ownership. So these kinds of transfer exchange, these are the transfers between 2 living persons. That means transfer inter vivos, 2 living voices. When it comes to transfer of property of a dead person to a living person, it is by way of a will deed. The will executed by a dead person owning a property will be transferred upon the last breath, that is the last, upon the death of the testator. And the transfer would take effect only after the death of the testator, and the testator is having right to revoke the will at any time. He can write a will afresh. So will deed. This is also one kind of transfer from dead person to the living person. So other than transfers inter vivos like sale, gift, mortgage, lease, and will deed, which is governed by Indian Succession Act, and proof of will deed, section 68 of Evidence Act. Other than these transfers, if a person dies intestate, transfer by operation of law. That means if a person who did not execute any testamentary disposition, that's what the definition of intestate says in the Succession Act. Intestate means a person who did not execute a will deed or any testamentary disposition capable of being into effect. That's what the words used in the definition. That means if a person executes a will, then if the will is proved according to law, the intention of the testator, owner of the property, should be implemented by the courts if it is proved according to law. You know, proof of will is very difficult task because the beneficiary has to dispel the suspicious circumstances. That means he need to clear all the doubts that would be cropped up in the mind of the court, in the mind of the judge. Therefore, friends, will deed, if the will deed is up, if the person executed a will deed it is also again comes to testamentary succession. Therefore, Succession Act cannot be relied upon. But if the person executes a will deed, but the will deed is not proved according to law, or the court did not believe the will deed, then the courts again fall back into Hindu Succession Act. So therefore, if a person owning a property did not write any will deed or any document with regard to the manner in which the property has to be distributed among his legal aids, then we have to refer to the Hindu Succession Act. And Hindu Succession Act also useful when we need to find out who all are the legal aids of the deceased person. Sometimes a contract has been entered by a person for purchasing a property. During the validity of the contract, the person dies. Then his legal aids can enforce the contract. Section 15 of Specific Relief Act says who can be plaintiff. So to find out who all are the legal aids of the dead person, in whose favor a contract has been executed, need to refer to the Hindu Succession Act. Again, we have to refer who all are the legal aids and who can be and who are having right to enforce the contract. Similarly, friends, Section 34 of Specific Relief Act, declaration, suit for declaration. If a person dies without any will or any document with regard to his property, then the legal aids wants to get the property of the deceased mutated in their names, then they need to approach the concerned authorities, Tehsildar or GHMC authorities or municipal authorities to claim some benefits from the bank or some other institutions, insurance policy, or if there is any denial of their status or right or liability, then we have to fall back and again on Succession Act to know who all are the legal aids of the deceased person. And Section 19 of Specific Relief Act, which also says against whom you need to file a suit for specific performance. If a person executes the agreement of sale, intending to sell his property, and if he dies during the validity of the period, his LRs are liable to fulfill the promise made by their predecessor in title. So, Succession Act basically deals with intestate succession only in the absence of any document by the owner of the property, and it is a transfer by operation of law. And succession, what is succession? You know the term, literal meaning of the term succession, successor in title, predecessor in title, all these terms are there. So successor to the office, successor to the property, successor to the estate, predecessor in title, from whom the legal heir derived title, he is called predecessor in title. These terms you should know, friends. Then again, so far as the Hindus are concerned, Hindu Succession Act 1956, Hindu law has been codified after 1955, 55 Hindu Marriage Act, thereafter Hindu Succession Act, Hindu Adoptions and Maintenance Act, Hindu Minority and Guardianship Act. These four enactments codified Hindu law. Before that, there was uncodified Hindu law. By advent of this Hindu Succession Act, female has been considered as absolute owner of the property, Section 14. And there is a provision, Section 6, which has been retained, adopted from the uncodified Hindu law co-personary property, Section 8, male Hindu succession, and Section 15, female Hindu succession. There are other provisions which deals with escheat, failure of heirs, whether there are any disqualifications, and whether the property of co-sharers can be sold freely without there being any conditions. These things have been mentioned in Section 1 to 30 of Hindu Succession Act. Basically, this law applies to all Hindus. Who is a Hindu is being defined in the Act. Any person who has been practicing Hinduism, a Hindu, and offshoots of Hinduism, Buddhists also can be considered as Hindus. It won't apply to Muslims and Christians. So friends, these are the definitions given in the Hindu Succession Act, and it also won't apply to certain classes of scheduled tribes. STs for certain classes of scheduled tribes, Hindu Succession Act may not apply. The tribes which have been notified by the President of India because of Article 366, Clause 25 of Article 366, there is a schedule. In that schedule, certain classes of scheduled tribes have been mentioned. They are outside the purview of the applicability of Hindu Succession. So whenever a case comes with relate to the succession of the scheduled tribe, we need to check that whether their tribe has been mentioned in clause 26, 25 of Article 366 of Constitution of India. That means President would give a notification in the official gazette of the Union of India so that that tribe will be outside the purview of the Hindu Succession Act. And when it comes to category of properties, to which properties it applies? It applies to all the properties, movable and immovable. And there is a difference of succession between the properties like self-acquired property and co-personal property. Therefore, there is a difference. This is with regard to male Hindu succession only. Again, this is with regard to male Hindu succession. If a male person dies intestate, I'm saying intestate, friends, because it applies to only intestate succession. We need to check whether the property possessed by the male Hindu as on the date of his death, whether it is a self-acquired property or ancestral property. If it is a self-acquired property, it is very clear there are 21 categories of persons which are mentioned in at the end of the Act schedule. Class 1 legal aids. Firstly, the property devolves upon the Class 1 legal aids. If a person dies intestate, leaving his self-acquired property, the property shall be devolved upon all the Class 1 legal aids equally, which means his Class 1 legal aids would take the property in equal shares. There are 21 classes of persons. And in the absence of Class 1 legal aids, if there are no Class 1 legal aids, then the property goes to Class 2 legal aids. In Class 1, mother is there, wife of the deceased, children of the deceased, predeceased sons or daughters, children, all those categories are there. In the absence of such relatives, the property goes to Class 2 legal aids. Class 2 legal aids, father has been included. Thereafter, Class 3, agnates and cognates, and Class 4. So, in case of self-acquired property, there is no confusion. There are no conditions. The only thing is the relationship should be mentioned at the end of the schedule, either in Class 1, Class 2, or Class 3, Class 1. Only in the absence of Class 1, the property goes to Class 2. If there is any one Class 1 legal aid, the entire property goes to that Class 1 person. We have to calculate the shares. If there is any dispute with regard to distribution of the property, the shares has to be calculated according to the rules mentioned in Section 10. So Section 10 is meant for distribution of the property among the Class 1 legal aids according to Section 8. So Section 8 to be read along with Section 10 and the schedule. This is with regard to self-acquired property, friends. So for inheriting self-acquired property, daughter and son are equal, wife, mother of the deceased, all are equal. They are entitled to equal share. There are no conditions. So this is the confusion. Oftentimes the judges or advocates entertain. I say if a partition suit is dismissed, partition suit cannot be dismissed because if there is a property, if the person dies intestate and if there are any legal aids, then the suit has to be decreed if it is in case of a self-acquired property, because there should not be any condition for acquiring the self-acquired property by the Class 1 legal aids, except the one mentioned in Section 25, that is murderer is disqualified. Murderer is disqualified to inherit the property of the person whom he murdered. So there are no conditions mentioned for distribution of the property among the legal aids, that is class 1 legal aids under section 8. This is self-acquired property. Then with regard to ancestral property, what is the ancestral property? You should know the difference between self-acquired property. There are various kinds of the properties in the nature of their acquisition. That means if two persons purchase a property, if I and other person purchase a property, it becomes our joint property. That means if me and Bhaskar sir purchase 5 acres of property jointly, and we obtain a joint registered sale deed in our names, then the property belongs to our joint property. So we both have equal share in the property. That is an essential feature of joint ownership, co-ownership. That means I contributed half of the consideration and the other purchaser contributed half of the contribution. So we are entitled to 2.5 acres each. But friends, as long as our shares are divided, we are entitled to enjoy 5 acres, entire 5 acres. In every inch of the land, we have a right. Even I contribute consideration for 1 acre, I'm entitled to enjoy the entire whole 5 acres of property, as long as my share has been crystallized by a final decree in a partition suit, and I have been allotted. I'm allotted a specific share in the 5 acres of the property. This is the essential feature of co-ownership. Co-ownership means the person enjoys the entire property along with the other co-owner, other owner of the property. So it is a joint property, and sometimes we can specify the shares in the deed we obtain from the buyer, seller, and we can demarcate the property to enjoy the specific shares in the sale deed also. So this is a joint property of both the purchasers. Then joint family property. Joint family property means if a person living with all his sons, daughters, daughter-in-laws, mother, father, and brothers, everyone, all those Hindu joint family, HUF property, Hindu undivided family. And if they do some business and they pool the entire money, entire income of the joint family, and they acquire properties, they pool entire properties are income of the joint family in a common hotspot, we call. If they put the income, that is called blending of income, and if they treat that as a joint family income, they can divide the property by filing a suit for partition or by way of a family settlement. It is joint family property. Joint family property, joint property, and self-acquired property. Self-acquired property, if a person earns out of his profession, employment, it is a self-acquired property. A person is a chartered accountant. He earns money out of his profession. A person is a lawyer, doctor, painter, actor, whoever it is, whatever the profession may be. If he earns out of his profession, avocation, if a person wins a prize, he participates in KBC, and he earns he gets a lottery or something else, and government assigns a land to him. All these properties would become self-acquired properties of the said person. It is a property which he acquires from his father, grandfather, or great-grandfather. So that property would become his co-personary or ancestral property. Have you got the difference, friends? So if a person gets the property from his father, grandfather, or great-grandfather, that property alone would become co-personary property. The rest of all the properties, the person was gifted with a property by one of his relatives, it would become his self-acquired property. But if a person gets property from his father, grandfather, or great-grandfather, it would become co-personal property in the hands of his sons. That means that is the only property that would become co-personal property. For distribution of such property, such co-personal property, the rules are different. So for a self-acquired property is concerned, properties are concerned, if a person dies intestate by leaving self-acquired property, section 8 would come into picture. The rules of distribution are mentioned in section 10, and there are no conditions. Only thing is their relationship should be mentioned in the schedule, that is class 1, class 2, legal aids. But in case of co-personal property, there are certain rules. Co-personal section 6 has been retained from the adopted from the uncodified Hindu law, and so far as co-personal property is concerned, if a person dies intestate, the property should be distributed among the co-partners only. And what is a co-partner? Co-partner means it is also within the joint family. Joint family is a bigger concept. Every member of the family becomes the joint family members, but co-partner is restricted to one small association of individuals, that is common ancestor plus his 3 male lineal descendants. So 4 generations, common ancestor plus including his 3 male lineal descendants. These would become co-partners. They are alone entitled to a share in the co-partner property till 1985 and thereafter 2005. So before 1985 and 2005 amendments, co-partners are common ancestor and his 3 male lineal descendants. They alone are entitled to share in the co-partner property. And the distribution is mentioned in section 6, how to share the co-partner property among the legal aids, and the branch of one co-partner becomes entitled to how much share. All these things have been mentioned in uncodified Hindu law. Section 6 is the guiding factor now. Then the change has occurred in section 6. For the first time, the government, Dadhan government of Andhra Pradesh brought an amendment to the Succession Act. When late N.T. Ramarao was the chief minister, he brought an amendment to the Hindu Succession Act, conferring co-partner status on the daughter of a co-partner. Not again 3 generations, female generations. It is only daughter of a co-partner is also entitled to a share in the co-partner property. For the first time, that status has been conferred in 1985. An amendment was brought to Hindu Succession Act, AP State Amendment. And friends, for conferring the status for getting a share in the co-partner property, to claim a share in the co-partner property by the daughter, she need to fulfill certain conditions. The condition is only with regard to marriage. Her marriage should not have occurred on or before 5th September 1985. That means unmarried daughter as on 5th September 1985 alone is entitled to a share in the co-partner property. So far as the state of AP is concerned, as on 5th September 1985. So prior to 5th September 1985, daughter is not the co-partner. She is not entitled to share in the co-partner property. Co-partner property, as I already discussed, it is a property inherited by a person from his father, grandfather, or great-grandfather. Then daughter became co-partner from 5th September 1985, subject to the fulfillment of the condition of marriage. That means unmarried daughter alone is entitled to share in the co-partner property. The crucial date is 5th September 1985. The AP model has been followed by various states, Karnataka, Maharashtra and Tamil Nadu, and throughout India, an amendment is brought, that is conferring equal status on the daughter to get a share in the co-personal property by virtue of amendment to Section 6 to the Hindu Succession Act, the Amendment Act of 99/2005. In 2005, the amendment was brought, and from that date onwards, Section 6 has been amended. Daughter of a co-partner throughout India, then starting date 9/9/2005, and again there were two conditions put. One is properties, the co-personal properties should not be partitioned among the co-partners as on 20th December 2004. The crucial date here is 20th December 2004 because the bill was put on the table of the parliament on that date. Therefore, from 20th December 2004, whatever the properties, co-personal properties available for partition, in all those properties, daughter would become entitled to a share. Daughter of a co-partner would become entitled to a share. Then another condition is the properties shall not be, if at all partition, that should be by way of a court decree or a registered partition. Otherwise, what would happen? The brothers would, the male members of the co-partner would put forth their claim of partition on a simple partition deed. That is not admissible, friends. It is the partition by way of court in a suit for partition or by way of a registered partition deed. Then only that should have occurred prior to 20th December 2004. Then only the daughter is not entitled to share in the property. If the properties are intact without there being any partition, daughter is also entitled to a share in the property. Now the question comes, whether daughter who has been debarred from getting a share by virtue of 1985 amendment, having married prior to 1985, whether entitled to share in the co-personal property if the properties are left unpartitioned by virtue of 2005 amendment. The answer is yes, friends, because if at all the properties are left unpartitioned, then the daughter whose marriage occurred prior to 1985, she is entitled to share in the property by virtue of 2005 amendment of Central Amendment, and if subject to fulfillment of the condition mentioned therein that the properties are available for partition. So whenever a person claims a share, whenever a daughter claims a share in the properties of a deceased person, the first thing we have to notice is what is the nature of the property. Sometimes judges have been dismissing the suits for partition filed by daughters in respect of self-acquired property also, but it is not correct. For acquiring self-acquired property by a daughter, there are no conditions, friends, because she is entitled, being a class 1 legal heir under Section 8 by virtue of Section 8 of the Succession Act. But so far as co-personal property is concerned, there are certain conditions. She needs to fulfill those conditions, but not otherwise. So what we need to see is whenever a female client approaches, a daughter of a co-partner, a daughter of a person dies, approaches and asks you to file a suit for partition, then what you have to do is, what are the nature of the properties left by the, first thing we need to ascertain from the client is whether the person left any will deed. The person executes a registered will deed or any will deed. In fact, registration is not required for a will deed. If a will deed is there, if it is produced from a proper custody, then if it is with attestation and all these conditions are fulfilled, that has to be implemented. So first we need to ascertain whether there is any will deed. If will deed is not there, then what are the nature of the properties? Nature of the property, self-acquired, co-partner. A person may have share in the co-partner as well as self-acquired property as on the date of his death. Therefore, Therefore, we need to ascertain them. We need to separate them. We need to draft the pleading in such a way that the court would understand the nature of the property, so that the court would be in a position to take a proper decision. Pleadings are very important. Then the other thing is, what are the conditions, whether the conditions are fulfilled or not, so far as the co-personal property is concerned. And one more thing is there, very important thing, that is, who all are the legal heirs of the deceased person, who all are the relatives, and which law, which provision of law would apply, and whom to implead as defendants. Because when a suit for partition is filed, Order 1, Rule 9 CPC says a suit can be defeated in case of non-joinder of a necessary party. If necessary party is not included, then the suit would be dismissed. Properties can be included even before the final decree. Even after passing of preliminary decree, properties can be included at any time, but the parties must be impleaded before the preliminary decree is passed. Therefore, friends, the daughter comes, we need to ascertain the nature of the property. Then there shall not be any confusion with regard to section 8 and 6. So far as section 8 is concerned, daughter is always entitled to share if she is a class legal heir. So far as section 6, conflict between state and central amendment, there is a judgment of High Court delivered by Justice Shiva Shankar Rao garu in Anuradha versus Chandrakala. In that case, the provisions have been clearly dealt by the High Court. It is B Division Bench of High Court, Justice R. Subhash Reddy and Dr. B. Shiva Shankar Rao, B. Chandrakala versus A. Anuradha. In 2016, a judgment has been delivered. Article 256 Constitution of India, all those things have been in detail explained in this judgment. And there are several judgments. One is Prakash versus Pulavati in 2016, and in 2018 Mangammal versus T.B. Raju. These two judgments created a confusion, stating that daughter, to get a share in the co-personal property, her father should be alive as on the date of 9/9/2005. That's what the proposition of the judges in those two cases. One is Prakash versus Pulavati, and the other is Mangammal versus T.B. Raju. These two judgments, section 6, while interpreting section 6, they said section 6 is not a retrospective provision. Therefore, father should be alive as on 9/9/2005, because the daughter of a co-personal term has been used in section 6. Therefore, she is entitled only if her father is alive. That's what the proposition. But in its early another judgment, Supreme Court in Danamma case, it says daughter of a co-personal is entitled to equal share irrespective of her father's death or life. That these equal, since these judgments have been delivered by the strength of equal judges, the matter has been referred to a larger bench. The larger bench, in a recent decision, Vinita Sharma versus Rakesh Sharma in 2020 Supreme Court, Vinita Sharma concluded that father need not be alive for a daughter to claim share in the co-personal property. Friends, please remember this condition of marriage as well as registered partition, court decree partition as on 20th December 2004. All these conditions are applicable only to co-personal property, not self-acquired property of the deceased. A person dies intestate. The two again, male intestate, male Hindu dying intestate. If he left with co-personal property, these conditions would apply. So in Vinita Sharma judgment, Rakesh Sharma judgment, Supreme Court categorically mentioned all these things at the concluding paragraph. They summarized the law and they put the controversy at rest. They said father need not be alive to claim daughter a share in the co-personal property. And what all the male members can oppose a suit for partition filed by daughter in respect of co-personary property is they should demonstrate that the properties have been partitioned by way of a registered instrument or by way of a court decree partition as on 20th December 2004. That is the only defense. Again, other general defenses like ouster and adverse possession, sometimes exclusive possession, can be established, waiver, all these things can be established. They are left intact in the judgment, they have categorically mentioned, but they have to be pleaded and proved according to section 3 of Evidence Act. So friends, this controversy has been set at rest by Vinita Sharma judgment, but still there is a one more controversy is left. The thing is, if a person gets property from his father and he is unmarried, after the death of his father he marries, whether his son would get any share. This doubt may crop up in mind for many. If a person gets the property from his father or his grandfather, at that time he is alone, he is a bachelor, he is unmarried. After few years, he got the property has been mutated in his name and he became owner of the property. Then he marries and gets children. Then what is the effect? Whether he would get share in the property, whether the newborn son, the son who had taken birth is entitled to share in the property. In various judgments of Supreme Court, Commissioner Wealth Tax versus Chandar Sen, and Sheila Devi and others versus Lal Chand, Commissioner of Wealth Tax versus Chandar Sen, Sheila Devi and others versus Lal Chand, Rohit Chauhan versus Surinder Singh. In 3 judgments, Supreme Court says even there is a sole surviving co-partner, after the death of the grandfather, if the birth of the grandson takes place, the nature of the property would not change. That means, since the father got the property from his father, therefore it would become co-partnership property in the hands of his sons. The nature of property would remain unchanged. That means it is co-partnership. Once a co-partnership property, always a co-partnership property. Co-partnership means common ancestor, including his 3 male lineal descendants. The first person dies and the 4th person will be added from the bottom. So within them, the co-partnership continues and the nature of property would be co-partnership property. But this judgment, another judgment, Uttam versus Saubhag Singh. In Uttam case, this ratio has been changed, friends. Uttam versus Saubhag Singh, Justice Nariman says, once property is devolved upon a person, intestate succession by virtue of Hindu Succession Act after 1956, by virtue of section 4, because of overriding effect of the act, the nature of the property would get changed. It becomes a self-applied property. That's what the proposition laid down in the case of Uttam versus Saubhag Singh. Therefore, again, friends, there is a difference of opinion with regard to changing of nature of property, co-partnership property, that is pending before the larger bench again. So, hope Supreme Court would answer this issue also soon. As long as my opinion is concerned, otherwise there will be no concept of co-partner. Therefore, the judgment in Uttam versus Saubhag Singh may not be correct, because the essential characteristic of co-partner is acquiring right by birth. If any birth take place, the property would goes to the common ancestor plus 3 male, including 3 male lineal descendants. Therefore, it would continue to be the co-partnership property. So, unless and until, since the judgment of all the cases with the equal number of judges, we can rely according to the facts and circumstances of each case. Then, friends, with regard to self-acquired property, we have already discussed. Daughter is entitled to share in the self-acquired property with regard to male Hindu dying intestate. So far as the male Hindus are concerned, there are two categories. One is self-acquired and co-personal property, section 6 and section 8. But in case of female Hindu dying intestate, prior to 1956, female was not considered as entitled to get a share in the property. Absolutely, she is entitled to interest in the property during her lifetime only. Therefore, she can enjoy the property during her lifetime, and after her death, the property reverts back to the male legal heirs, male persons in the family. But Section 14 of the Hindu Succession Act confers a status, independent status on women. She is entitled to held the property as its absolute owner. That means this is with regard to all the properties acquired by her, whether before or after the commencement of the Hindu Succession Act. Whatever the property got, that is by virtue of maintenance or in lieu of her maintenance, a property is given to her. The property has been gifted to her mother-in-law, father-in-law, or father, mother, or husband, or any other relative, or even it is mentioned even by adverse possession. If a female acquires a right by prescription, if a female acquires a right over any immovable property, and that property, so far as that property is concerned, she would become absolute owner of the property. That means she is the full owner of the property. Therefore, except one provision, subsection 2 of section 14, which says that by virtue of any court decree or any document of maintenance, if female a right in the property is restricted to a female, then so far as that property alone, other properties, she would become absolute owner. This was not there.
We have one question in the chat. Would you like to answer now, or do you want to retain it to the end?
After.
Okay, we'll hold it to that. Thank you.
Please ask them to reserve their queries.
Yes, sir. They are raising it. Yeah, thank you.
Then female becomes absolute owner, except one condition. If any property is given to her with a condition, that condition has to be honored under section 14, subsection 2. Again, this condition may not be correct in view of the law of property. Law of Transfer of Property Act says any condition put with regard to enjoyment or alienation of the property is void. That's what the law of property in this country says. Therefore, there is again some confusion, but transfer of property is a general law of property and Succession Act is a special law. Therefore, this would prevail. That condition in section 14 class 2 would prevail. Except section 14 class 2, female becomes the absolute property. Since female became absolute owner, she is entitled to hold a property. What happens if she dies intestate? Again, friends, it is also with regard to intestate succession. If a female dies without leaving any will or any document with regard to the manner in which the property has to be disposed of after her death, that means capable of being, with regard to disposition of the property after her death, the female, if she did not write any will or any other document, who are entitled to share in the properties, share in the property of a female Hindu dying intestate. The rules of succession with regard to female Hindu are mentioned in section 15, friends. Section 15, there are 5 categories of persons. One is, first category is sons, daughters, and husband. Section 15A, sons, daughters, and husband would take equally. Son of a female lady, sons are son, daughters are daughter, and husband. They would take the whole property. In the absence of son, daughter, or husband, the property goes to aids of husband. Legal aids of her husband would take class B. Then In the absence of legal heirs of her husband, the property goes to her mother or father. Property in the absence of sons, daughters, husband and legal heirs of husband, then only the property goes to her mother and father. Upon the heirs of father, in the absence of A, B, C, the property goes to heirs of father. In the absence of A, B, C, D, the property goes to heirs of mother. So the order of preference is given from section 15A to 15E. This is a manner in which the property has to be distributed among the legal heirs of a female Hindu dying intestate. Then there are two provisions. There is a condition that with regard to the property got by a female from her father. Clause A says, firstly, sons, daughters, and husband. In the absence of first daughters, husband, and sons, the property goes to heirs of husband. But that may not be proper. She gets the property from her father. In the absence of sons, daughter, and husband, the property goes to the heirs of her father. That's the condition put in section 2. And 2A, 2B are there. If the property comes from her husband, the property goes to husband heirs. All other property goes to section 15A, B, C, and D. So the manner in which the property has to be distributed, that is being mentioned in section 16. Section 8 to be read along with section 10. And section 15 to be read along with section 16. So the manner of distribution means the branch. For instance, there is a person who, in case of male Hindu, dies intestate. He left with one son, daughter, wife, and mother. Simple suit for partition. So the person dies intestate. The property has to be divided among the 4 class 1 legal heirs: son, daughter, mother, and wife. Even though father is there, he is not entitled to any share because he is in class 2 legal heirs. Therefore, 4 shares among son, daughter, wife, and mother. If there are 2 sons and 2 daughters, the property will be divided equally among them. That becomes 1/6 share. Then, before that person's death, one of his sons dies. What happens? That means if the son dies by leaving his wife, that is daughter-in-law of the person or grandchildren, the branch of the son would get another share. This procedure has been mentioned in section 10. If you read section 10 carefully, you can understand by way of a chart we can explain. Similarly, section 15, the manner of distribution is mentioned so far as 15 is concerned, that is mentioned in section 16. So friends, this is the manner of succession with regard to female Hindu, and a female has become absolute owner of the property, section 14. And if she dies intestate, the property has to be distributed along according to section 15. And the person, among the persons, that has to be distributed according to section 16. Section 8 read with section 10, section 15 read with section 16. Then the conditions are, again I am repeating, the condition with regard to inherit personal property is section 6, and AP Amendment Act is concerned, unmarried daughter, 5th September 1985, and so far as the Central Act Amendment is concerned, the property should not be partitioned as on 20th December 2004. And if at all there is a partition, that should be by way of a court decree or a registered partition. Then only the daughters is not entitled. Then friends, there are certain other provisions in Hindu Succession Act, section 22. Full blood, off blood relatives. Full blood relative will be given preference than off blood, section 18. And section 20, right of child in womb. Section 20 says, if a woman files a suit for partition in respect of her brother, in respect of property of her father who died intestate, against her brother, mother, and brother, mother, and herself, claiming 1/3 share. As on the date of death of her father, her mother was carrying and 3 months pregnancy, and during the pendency of the case, she gives birth to another male or female child. Then what is the effect? Means she need to implicate the child also, because as on the last breath of the person, as on the last at the time of death of the person, if any one of the heirs, female heirs, carrying a child in the womb, the child would get a share in the property. That's what mentioned in section 20 and 21. This is also very important. Presumption as in case of simultaneous deaths. If father and son, while traveling in a car, unfortunately accident occurs and they dies, and it may not be possible to predict the exact time of death even by post-mortem examination, because they died simultaneously. Then what is the law? Because depending on the time of death, the succession varies. Time of death of the person, father and son. Therefore, law says the law of nature is younger survives the elder. That means younger survives and the elder dies first. That is the law of the nature. The Succession Act also recognizes that law. Therefore, they put in the provision, section 21, that says we should presume, the court should presume that younger is survived and elder died first and thereafter younger. That is what mentioned in section 21. Then preferential right to acquire property in certain cases. You may be getting queries that my brother is selling the property, whether I can, even after partition, whether I can restrict him from selling the property. They can file a suit for injunction, restraining him from selling the property because it is a family property. Section 22 says preferential right, suit for preemption. That means if 2 persons or 3 persons share the property, co-owners. For instance, there is a building, 3 floors are there. It's been distributed among 3 brothers. One of the brother, it has been distributed and everything is over. Each one of them residing in their specific allotted portion. When one of the brothers wants to sell the property, whether the other 2 can restrain this person who is selling the property. They can't restrain him, but what they can do is they can offer to buy the property. They can ask him to sell the property to him, to them, to any one of them, other than the third party, because it may not be appropriate to invite third parties to a family. Therefore, they can file a suit. That suit is called suit for preemption to enforce the right of preference. Preferential right under section 22 of the Succession Act. The court would determine the price and consideration. If falsely that person files a suit without intention of buying the property, but to trouble the other sharer, if a person falsely files a case under preemptive suit, the court can impose costs on such false suits. The person who files false suit. If there is a competition among other 2 brothers to buy the property of the other brother, then the court would decide the person who offers the highest bid, that means who offers the highest price, will be given preference for purchasing that property. So this is what mentioned in section 22, friends, 22 of the Hindu Succession Act. Then earlier there was a concept, dwelling house. Dwelling houses cannot be partitioned. Sister can prevent brothers from partitioning the property if it is a dwelling house. That has been removed. That provision has been removed from 999/2005. Similarly, doctrine of pious obligation. That means a person that is mentioned in section Succession Act, a person who is able to pay who can pay the debts of the legal debts of their father, their ancestor or predecessor in title, they are not entitled, they are not liable to pay the debts unless if they acquire any property. Estate of the deceased is liable, not there is no personal liability now. Doctrine of pious obligation has been removed. And with regard to remarriage, what is the effect of remarrying? If a female gets the property right in the property of her husband, then if she remarries, what happens to her property, her right? The right remains intact, because the moment her husband dies, she would get the property, and her remarriage would not take away her vested right in the property. That is what mentioned in section 24. 24 has also been removed. Then what is the effect of disqualification? Certain disqualification. One is conversion, and the other is crime, murderer. Convertant descendants. If a person converts himself into a other religion from Hindu religion, the convertant's descendants and the person converted is not a Hindu, therefore he is no more entitled to share in the property of Hindu successor, Hindu ancestor or Hindu predecessor in title. Similarly, his legal heirs are also not entitled. There is a judgment on this aspect. A person converts, that is with regard to section 27, Vellikannu case, Vellikannu. In that section 27, if a person commits the murder of the person whom he wants to inherit the property, he is not entitled to get a share. He is disqualified by virtue of section 27. Vellikannu versus R. Singaperumal. This is with regard to 25 and 27 of Hindu Succession Act. Murderer disqualified, convertant descendants disqualified, and 27 succession when legal heir is disqualified. These three provisions have been discussed in detail in this judgment, 2005 Supreme Court, Vellikannu versus Singaperumal, R. Singaperumal. So these judgments, this judgment, they clearly describe that if a murderer is disqualified from inheriting the property, his children are also disqualified. Children or wife, whoever it is, they are also disqualified from inheriting the property of the person died because of the murder committed by the legal heir of the deceased. Then disease and defect. If a person is affected with any venereal disease or some disease, HIV or something else, that is not a disqualification at all. The law says disease or defect not to disqualify from inheritance. Disease and defect are no more disqualifications. And the last one is section 29, failure of legal heirs. If a person dies intestate and no one is there, class 1, class 2 or any, no one mentioned in schedule are there. If a female dies without leaving any of the legal heirs mentioned in section 15, the property goes to government, estate. Whatever the property left by the person, that goes to the government. The government would take the property subject to the liability. That means if any loans or liabilities are there over the property, the government need to discharge those things. Then the property goes to the state government. So friends, these are the provisions in the Hindu Succession Act. Basically, two varieties of properties: co-personary and self-acquired. Self-acquired male section 8 and female section 15, and co-personary property section 6. So while drafting a suit for partition, one must be thorough with all these provisions, because once a suit is drafted, there is a chance that it may reach the hands of a Supreme Court judge if the matter is carried up to Supreme Court by way of an SLP. The judges before that court may interpret the pleadings, may read the pleadings and interpret the pleadings. Therefore, they are very much important. Pleadings as well as pleadings in the plaint as well as in the written statement. So, we thought that it is a practical approach. Therefore, after this introductory speech, it's now time for queries. If you have any query, you can ask now.
We had two questions coming up in chat. One from Ramaji, stating that the woman has filed a suit for partition against defendants, and defendants took a plea of oral partition, further seeking defense for such partition being affected, which is admittedly which is also admitted by the plaintiff. In such case of oral petition, as the new judgment says, some document has to be just to request to throw some light on oral partition and its maintainability.
Okay. Oral. First of all, the query says that the plaintiffs have also been admitted about the oral partition. So admitted fact need not be proved. Section 56 of Evidence Act. Facts which have been admitted need not be proved. Therefore, there is a oral partition. There is a partition. When there is a partition, again, there is no question of partition. And partition must be a registered, by way of a registered one. That principle applies so far as barring the daughters from getting share in the co-personary property. And when the plaintiff herself admitting that there was an oral partition, her pleading is inconsistent with the relief. Therefore, she is not entitled. Any property to divest from one person to the other person, even before the co-owners, that should be by way of a registered one. In Vinita Sharma case, Vinita Sharma case, the judges mentioned certain rules. And they have also mentioned that, again, with regard to partition and all, proof is required. Pleading of ouster and all these things are concerned, proof is required. When already a proof, the fact has been proved because of the admission on the part of the plaintiff, therefore, there is no question of proving again, and the judges can give finding with regard to oral partition, and the partition suit may be dismissed.
We have one more question from Monica. Monica, would you want to unmute yourself and ask?
Yes, sir. Good afternoon, sir. So I wanted to know about section 22 and 23. I didn't understand the provisions of 22 and 23.
22 is a preferential right of the co-sharer to ask the court to give preference for purchasing the property when the other sharer wants to sell it to the third parties. That is 22. 23 is removed. Earlier there was a bar for claiming partition in the dwelling house. Daughters cannot ask for partition in the dwelling house. Suppose there is a building at Banjara Hills. It is a 10-storied building. Brothers are living in it. Whether daughter can ask for partition, earlier it was not there because it is termed as a dwelling house. Now that has been removed. Even in that building also, even in the dwelling house also, if they have share, they can ask for partition. That is 23. 23 has been removed from the act. 22 is a right conferred on the co-sharer to seek preference for purchasing the property when the other co-sharer wants to sell his share, not the joint property, his specific share which has already been partitioned. The suit is called preemption, suit for preemption.
Thank you, sir.
Sir, I have a question here. So the question is like, are there any rights for granddaughter in case of ancestral property? And does a father of a daughter has a right to sell the property without the consent of her daughter?
So far as the granddaughter is concerned, it is not there, sir. The section 6 confers the right on the daughter of a co-partner. Unlike sons, males, there is again some discrimination with regard to inheritance of co-partner property. So far as male successors are concerned, it is restricted to 4 generations: father, grandfather, son, and 4 generations from commencing from computing from top, common ancestor and his 3 male lineal descendants. That means 4 generations. But so far as daughters are concerned, daughter of a co-partner alone is entitled, not the granddaughter. And what is the other one?
Without the consent, without the consent of the daughter, can the father sell the property?
No, now the father cannot sell the property because daughter became co-partner. This applies to co-partner property only. Again, I am repeating. In case of self-acquired property, he can do whatever he wants. Self-acquired property, he can sell it anytime, irrespective of the consent of daughter, wife, or anyone else. So far as a co-partner is concerned, he cannot sell during the lifetime, without the consent of other co-partners. That is male co-partners and female co-partners. Female co-partner now means daughter of a co-partner.
Thank you for answering that, sir. So I have a follow-up question related to this. So you said there are 4 generations which are involved in getting the property rights of this. So is there any specific term for that, for looking of encumbrance and all?
As of now, there is no specific, because we should know from inquiring personally how we can know the relationship of persons, whether there are any grandson is there or granddaughter, grandfather is there or great grandson is there. We cannot search like an encumbrance over property. We should inquire with the known persons.
Okay, thank you, sir. I have another follow-up question. If you permit, then I can ask that.
Yes, you can ask.
Yeah,
Could
thank
you,
sir.
if you could just hold on to that question for a moment, Srinivas. Raghu, can you continue with your question?
Yes, sir. Sir,
Try to maintain time.
Sir, some land is there. It was came from 6 ancestor predecessors. Now, whether the daughter who was married in 1980 will get share in that property. That is 1920s property, sir. It was purchased 6 ancestors back property. Shall a daughter get a share in that who was married in 1980?
1980. The
Yes.
thing is, according to you, her father got the property from ancestors. Therefore,
Yes.
it is a co-partner property first.
Yeah.
First of all, she failed to fulfill the condition of the AP amendment.
Yes.
Because her marriage taken place prior to 1985. Then next question comes whether she is entitled to share by virtue of central amendment. Therefore, the condition is properties must be available. Whether her brothers and father partitioned or not is the question. Whether they partitioned.
Not partitioned till now.
Till now, then she is entitled. She can maintain a suit for partition. She is entitled to share.
Okay, thank you.
We have a question from Rohini. Can you unmute yourself, please?
Yeah, thank you, sir, for the chance. Sir, my question is that there is a girl who has married to a Sindhi guy. That means marriage is between Hindus only. And the fellow dies and mother goes in the court for heirship purpose. So the court has given the permission, the court has ordered that the heirship certificate to her in case of 50-50%. That is 50% to the wife and 50% to the mother. But now, sir, the question is that the wife has already purchased a property when she had married to this fellow who died, who is a deceased now. And she had paid the loan also. And she has all the records related to the loan, whatever she has cleared it. Will that property be given in favor of mother also, as it is the husband's name was there in that property, and as the court has ordered 50-50%, will that also be given it to that wife or to that mother-in-law?
No.
The property purchased by the daughter-in-law.
What you said, if what you said is correct, that the property has been purchased by wife alone, and she contributed and she paid the loan, mother is not entitled. But why she kept silent before the court while granting Did she not produce all the evidences?
Sir, her mother was in cancer, and during that procedure, she couldn't attend the courts, and also there was a negligence on the part of the lawyer as well as the client. But the thing is that
then ask her to file appeal along with additional evidence and try her luck.
okay. So I have one more question. So the thing is that now, as you said that the father who has self-acquired the property, he can distribute the property. But he has made a will that there are 3 daughters and 2 sons living.
When there is a will, Succession Act won't apply, madam.
Pardon?
When there is a will, Succession Act won't apply.
So yes, that is right. But will is there. There are 3 daughters. Will is there with the second daughter, and the two sons who are living. They have no idea regarding the will or the contents in the will. They have not even probated the will. So in this case, what can we do for the co-personary property, for the property that is, or for the self-acquired property?
Filing a suit for partition. File a suit for partition, then entire truth will come out.
So an elder son, if elder son lives in that house where his parents were residing, and after 20 or 15-20 years, when the younger son comes and he asks for the partition, so what will be the defense for our side?
You are asking query or advice. The thing is, there is no limitation. There is no limitation for partition. You can file a suit for partition. You can take all the defenses. That means will and all other things. There is no limitation prescribed. At any time, as long as the properties exist joint, partition suit can be filed.
Okay, sir. Thank you, sir.
Hello?
Yes,
Sir,
yes, please go ahead.
Sir, my question is whether the right for preferential suit or preemption can be filed before alienating suit, or it has to be filed after the alienation is made by one of the co-partner or class 1 legal aid, sir.
Before alienation. After the alienation, the purchaser would get right. He becomes the owner of the property.
But in one of the suit, the judge has taken objection that the cause of action arises only after the alienation is made.
No. If alienation is made, it won't be the property of the co-owner.
Sir. Okay, sir. Okay.
It has to be, but you need to establish that he is proposing to sell the property. Let him file a written statement whether he is selling or not. If he says that he doesn't want to sell, then there is no cause of action.
Yes, sir. We have filed the suit before alienation, but the judge has taken the objection that the cause of action arises only after the property is alienated by the co-owner.
No. Once the property is alienated, he can't become the owner. He is not the owner. You can't file a suit.
Sir,
it would become infectious.
Okay, sir. Thank you, sir. Thanks.
Kiran, sir, can you please raise your question? I think it's around Muslim ancestral property, right?
Yeah, I'll ask a question on Muslim ancestral property, sir.
Please go ahead.
Dama.
Sir, one Muslim ancestral property is there, which is undivided. They have got 2 daughters and 1 son. 2 daughters, they got married sometime during early 70s, 1970s. Now they are claiming share in property, sir.
Sir, so far as Muslim
whether they are entitled to it.
Muslim law is concerned, there is no concept of co-partner. It is only confined to Hindu law. Mohammedan law is totally different. Male person get 2 shares, whereas daughters would get 1 share. There is a difference. There is no concept of co-partner.
Okay, sir.
He can file a suit.
We have 3 questions on chat which have come in early, which I'm taking right now. Ramesh is asking if the liabilities are higher than property value, how the escheat is dealt by the government?
Pro rata basis. All the creditors of the deceased person may issue a suit or insolvency petition or a suit for administrating the property of the deceased. Then the court would appoint a receiver and distribute the property according to section 73 CPC.
So we have
they need to file suit against the legal aids, mentioning that the property in their hands is their predecessor in title. That means deceased estate, and they need to file EP. Thereafter, the property will be distributed according to Section 73.
Ujjwal ji, can you just unmute and ask you a question?
Yes, sir.
Can you ask your question, please?
Good afternoon, sir. Yes, sir. Good afternoon, sir. My question is that what is the status of property of a deceased if the property is partly acquired by the deceased and partly by the sons of the deceased, sir? And now the daughters are claiming the property of the deceased wholly. So how can we, what is the remedy for it, sir? Can they claim?
So dead person and the alive person jointly acquired the property, according to you.
Mother and the sons jointly acquired a property, sir.
Then the remedy is again filing a suit for partition, and you need to mention in the pleadings which property, which portion has acquired. That means what is the quantum acquired by the sons and what is the quantum acquired by the deceased, and she is entitled to share in the deceased share.
Okay.
It is all calculations.
Okay, sir. We should prove it in the court that this part of the property is acquired, is bought up by the sons.
Yes, everything depends on proof.
Okay, sir. Will a release deed be more prevalent over the partition deed, sir?
No,
If
both are
partition has not yet happened, and if a release deed is hello, sir.
release deed means relinquishment of rights. Both deeds are different in nature. Partition deed is the person, for example, if a person leaves 3 or 4 legal aids and the property will be distributed by way of a partition deed. If in case of release deed, the sharer relinquishing a right in favor of the other existing legal aids. Both purposes are different, madam. So and stamp duty is also different. So far as relinquishment deed, they'll charge more. Stamp duty will be more.
Okay, sir. Yes, sir. Even before the partition deed, it is possible to apply for a release deed by any of the heirs.
Yes, among the heads, daughter can relinquish her share, but there should be some consideration for that.
Sujata ma'am, you can
Out
unmute
of
and
love
ask
and
your
affection also she relinquish her share. But that should be by way of a registered document.
Sujata ma'am, please unmute yourself.
Thank you, sir.
Yes, sir. Thank you, Sai. Sir, my question is for the property who he's the person is the property absolute owner. It's an self-acquired property, but it's under loan, and at the time of registration and in the banking procedure and all registration procedure, he has given his father name as a the person is no more now, and the wife and children are no way given any right in that property, and father, the deceased father is not supporting the family also. So like how can we help that lady? Like will a document like legal certificate will help? How do we get it? Like can I have any suggestion from you?
Is the thing, it depends on the document executed by the owner of the property in favor of the bank. If he deposits if he furnishes the property as a collateral security, the bank would take the property. His legal aids won't get any share, even if he stood as a guarantor. If there is no such document, he just signs as a nominee or a witness, the bank has no claim. Then the legal aids would get share. They need to file a suit for declaration. Vinita Sharma versus Rakesh Sharma.
Vinita Sharma. SEC?
SEC citation right now I don't have, sir.
Very well.
It is a 2020 Supreme Court judgment. You just type in Indian Kanun or Google, you would find.
Very well. Tomorrow I will get, no problem, from you. Okay. But another question I asked that which is the best instrument to transfer the house building, self-acquired property to son, will or gift? Which is the best, sir?
Gift. Because will will comes into play only after the death of the testator, and the testator, it all depends on the intention, because if he wants to reserve the right, then he can better execute a will deed. If he wants to convey the property immediately, gift deed.
Registered?
Will need not be registered, gift must be registered.
Thank you very much, sir.
I think that's the end of the list, sir. I think thank you so much for being patient and answering all our questions. With that being said, I'll give it over to Chaitanya, ma'am. Sir, unless you wanted to add something else.
No, nothing. Friends, I have very few words. Practice law with passion, because we need to strengthen the subordinate judiciary and the high courts. It should be a continuous affair. Legal education should be a continuous affair, because day in and day out, new propositions are coming, new enactments are being made, and everyone starting criticizing the judiciary. So feel that it's your institution and love this profession and do practice. That's all.
Thank you, sir. Kiran, can you pass on the word of thanks?
Valuable suggestions. Sir, on behalf of EGNA legal team and all the participants, I feel immense pleasure to thank you, sir, for our eminent speaker, Kiran Palakurthi garu, Bar Council of Telangana, who has paid time from his busy schedule to create this webinar. And deep gratitude to Sridevi Jamma and Bhaskar Palluri garu for providing us such sessions from speakers like you with well experience for budding advocates like us. And I thank all the participants who participated with great enthusiasm. I thank you all and have a nice day, sir. Thank you so much, sir.